Good morning, everybody. It's Tom Kline. Welcome. I am in the Blue Ridge Mountains, just west of Charlottesville. And today is June 27th, which means there's a new federal policy going into effect. And I haven't memorized it all yet, but I am going to use some notes here today, which I usually don't do. It's the Pregnant Workers Fairness Act, otherwise known as the PWFA. Today is actually the effective date. And what it's about, employers with 15 or more employees have to make reasonable accommodation for pregnant employees with a known limitation because of their pregnancy, childbirth, or their related condition. It's similar to the American with Disabilities Act, where an employer has to engage in an interactive process with the employee to determine what's a reasonable accommodation. So that reasonable accommodation standard is also part of the Pregnant Workers Fairness Act. That's a lot to say, the Pregnant Workers Fairness Act. And in that, the employee will need to provide medical documentation, just like the American with Disabilities Act. And that'll have to support their need for an accommodation. You can't require a person to take paid or unpaid leave as a part of this act. And the new statute, of course, will prohibit retaliation, coercion, intimidation, threats, or interference if a request is made. Penalties can include reinstatement, back pay, front pay, compensatory damages, punitive damages, reasonable attorney's fees and costs. Reasonable attorney's fees and costs are usually in the 40% range. And so that can be really expensive. Punitive damages are, of course, come from the Latin word that is meant to punish, punitive. And so that's an additional fee that a judge or a jury can impose upon you to make sure that you are paying for your bad acts or bad deeds. That's what punitive damages are. This was passed by the full Congress, but the House Committee on Education and Labor provided examples of a reasonable accommodation, which I wanted to read to you. The ability to sit, the ability to drink water, the ability to receive closer parking, flexible hours, appropriately sized uniforms and safety apparel, and additional break time for eating, rest, and use of the restroom. So, and it also will limit their need to do strenuous activities. So that is that's the new law as of today. So I wanted to make sure I got that to you. The Pregnant Workers Fairness Act, PWFA, which is effective today, June 27th, 2023. Also, while we're talking about that, you're required to get posters to put up with the rest of your posters also. These are available from lots of different places online. The Pregnant Workers Fairness Act, you can see it here. And so they're required to be posted. Also, while we're talking about this, we should discuss maternal protections for Nursing Mothers Act, which also hasn't gotten much publicity. This is also known as the PUMP Act, providing urgent maternal protection. And this was effective April the 28th of this year. And again, I have not memorized all that goes with that, so I'm going to use my notes today. A nursing employee is to be given a reasonable break time and place other than a restroom that's shielded from view to express breast milk while at work. This new accommodation is for up to 1 year after the child's birth. This applies to employers with 50 or more employees, but 50 or fewer may be exempt if compliance would impose an undue hardship such as causing difficulty in complying or an expense when considering the employer's size, financial strength, nature, or the business structure. Again, if you Google providing urgent maternal protection for Nursing Mothers Act, I'm going to say it one more time because it's so long. Providing urgent maternal protections for Nursing Mothers Act, or the PUMP Act. Obviously, I just want to make you aware of it today. If you have any questions, of course, call me and we can do a deeper dive together. The one important part of the PUMP Act is that prior to an employee actually taking an action against you for not complying, is the employee has to notify the employer of the failure, and you have 10 days to provide a private place for them to pump. If the employer terminates in retaliation or refuses to comply, then the notification period of 10 days is waived. So this brings up another quick item, which this stuff should be incorporated in your employee guidebook. Some people call it a handbook. Let me just take a minute and talk about that. So a handbook has connotations that everything is contained in that document. And when you go to court, plaintiff attorneys will make a lot of hay over the fact that if the policy that you have is not contained in the handbook, then it really doesn't apply, because the word handbook has connotations that everything is contained in it. And I've seen this on multiple occasions that plaintiff attorneys will say, well, you may have other policies, but why is it not in your handbook? And for that reason, I like to call it a guidebook, because a guidebook actually guides you. Dealerships always have policies that are not contained, because updating that guidebook is very time consuming and requires a lot of work and a lot of effort. It is work that I do, in case anybody was wondering, but I'd encourage you to take a look at your guidebook. If you haven't updated it recently, then consider getting it looked at by a professional attorney, an employment lawyer, a business consultant like me. But I'm also going to encourage you, even if I were to do it, I would encourage you to run everything by your attorney, make sure that there's nothing left out, as there's a lot of particulars in a guidebook, and things for you to think about. So codifying your policies and putting them in there will only help you when you have problems, when employees bring up problems. If employees go to the EEOC to try to say that you didn't treat them fairly, if it's in your guidebook and it's written and they have a signed acknowledgement, then it's a lot easier to defend yourself and explain what your policies are and how your policies work. So the more information that you can actually put in your guidebook, the better, to make sure that everyone understands what the policies are, right? Because that's the whole point of a guidebook, is so that all your employees know what the policies are and are able to find them. And there are a lot of policies, and I'll do a separate streaming on some of the contents of the guidebook and what should be there. But when you have the very important policies, I think it's critical to have your employees sign them and have acknowledgments so that they're in their employee files, so that you can say on your very critical policies like harassment and retaliation and the big things, so that you can, if anybody asks, or a plaintiff lawyer ever comes calling and wants to know why you're doing certain things, that you can say, look, the employee knew, they signed for this, but at a minimum, they should sign for your guidebook, that they understand it and that they've read it. So thanks for tuning in today to learn with me. I appreciate it. I'm Tom Kline. Have a great day, and thanks for seeing things from a better vantage point. Take care.